This video is about should Moors file diversity of citizenship complaints and the amount of controversy it caused. So I went over this in some videos a little bit, but I'm gonna elaborate on this a little more. Now, the reason why I'm putting out this video is because Moore said you should come over and argue diversity of citizenship. Now, if you all know that federal courts only hear a couple of types of cases, they're dealing with diversity and federal questions, but it also the element it has to be a controversy, meaning that there has to be something contractual or somebody is doing something against someone that they don't have the right to do um, within the contract. And you got to remember, people waive their rights all the time in contracts. They waive them. So you have to understand this information. So when arguing diversity of citizenship, I want Morris to think about this, and let's go over this statute, because I've seen this get thrown out too many times for it not being right. It says the district court shall have original jurisdiction of all civil actions where the matter in controversy exceeds the sum or value of 75,000 exclusive of the interest and costs and is between. Do you see this? First thing it states a matter in controversy exceeds. I just want you to look at this. Matter in controversy. So it has to be a controversy. So I try to tell people this is dealing in contract. People are going to say, well, no, it says right here, citizens of state and citizens or subjects of a foreign state. Means private state. This right here is, might as well say, a private state or private trust. Because you got to remember, states can contract with private persons. And you can waive, like the Constitution ain't applicable if rights been waived in contract. You can waive rights. So, a lot of more say, hey man, I'm going to go over here and diverse it and argue this element. But yet, they can't prove the controversy. So let's say the government took your car and you had private tags on there and certain things weren't done correctly to secure. Because remember, I always talk about perfection of a claim. You didn't have everything done. The federal court is not going to hear the matter because there's no controversy. There's nothing that you can define or show where the controversy lies. And let me explain how. A lot of Moors still have their social security number, working under their job, social security number, got credit cards, all these different things attached to that person or personality in which they're doing business with, filing taxes and all this stuff, but then they want to argue this. And you have to really understand how to go about doing this. So you have to really be careful with this, because I don't think most Moors know how to perfect this claim under this, because I've seen too many times where this happened. Let me show you this. When courts talk about rightness and mootness, they are referring to whether it is too early if the case is not right, or it's too late, the case is moot, for the court to decide the case. If the case is too right, the court is saying it's not the right time to decide the case. If the case look like, if you look at the Constitution, Article 3, Section 2 clause, the case or controversy clause, you will see that federal courts can only decide actual cases and controversy. So when the case is right and you have the right parties, the case is an actual case of controversy. The basic principle is that the court should issue decisions will affect the parties. So you got to understand, there has to be a controversy where one party is left without something, so the federal government come in to make them back whole. And you got to understand that. It says the court should not issue hypothetical decisions as to what happened if certain events were to occur in the future, or hypothetical decisions as to what should have happened in the past. See, you got to make sure you got to be right for this. And most of the time, I done seen too many Moors get their case kicked out because they're arguing the wrong thing. You're trying to move when there is no injury, when there is nothing that you can verify or show, when you should be arguing this. Let me see. Not that. With conspiracy to interfere with civil rights. When state actors are depriving you, let's say, for example, the way Muscat is set up, we have our public entity that interface with the private entity to secure records as the custodian, in which they're denying the entity to be able to, the public entity that's registered within the state, to do certain business that they were getting paid to do for, and there's no law prohibiting such action. That's a violation of their civil rights, of that entity's civil rights, because you're stopping them from being able to, under the contract clause, section Article 1, Section 10, you actually interfering with the rights of a contract, in which the state don't have a right to do. And if it's more than one person, it's a conspiracy to interfere with the rights. You get what I'm saying? So you got to understand this in its entirety. So arguing diversity of jurisdiction, most of the time, most Moors don't have the wherewithal. I haven't seen most of the people that I work with, and they telling people to do this, they don't understand what's really going on and how to adjudicate that or argue that or get standing on that. I done seen too many things happen. Let's look at, let me show you this. Now, jurisdiction. Federal courts have limited jurisdiction. This means they cannot hear all types of cases. They only can hear two types of cases. of federal jurisdiction, federal question, and diversity. So you got to understand when you coming in on a federal question or diversity, meaning there is a conflict between two or more different states. And then it has to be in the form of constitutionality if the state's even allowed to get in certain types of contracts if certain things haven't been waived. So I keep trying to tell everybody contract, 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 contract. I'm not going to say it enough. If you don't know how to contract, then you're going to find yourself in a lot of peculiar situations dealing with the court. So diversity, like I said before, and it tells you right here, should have original jurisdiction of all civil actions where the matter controversy, that term exceeds the sum or value. It has to be a controversy. This statute is dealing with contract. I'm going to say this again. This is not a deprivation of rights statute. And you got to be able to show the controversy. I just showed you this. I just read you, not that one. This one. Article 3, Section 2, Clause 1. The controversy clause. You will see that federal courts can only decide cases, actual cases, and controversies when the case is right and we have the right parties, then the case is actual a case or controversy. So you got to understand that the issues before the court, because most of the time when I seen that, most people don't get this right. I haven't really seen too many people get this actually right. Forrest Moores. Haven't really seen Moores get this right. So remember, everything is about contract. Everything is about dealing with the court as evidence. Everything is about trust management. Everything is about perfecting a claim. You have to understand that these are the things that's essential to win your case. If you don't know how to put stuff together, it's not going to work. So this was just a short presentation on this information so people can understand should they be arguing this diversity of jurisdiction when going to court. This is King L. Bay. I'm signing off. I want to say peace and love, Islam, to everybody that's been supporting me. I know I haven't been pumping out information, but I'm finna start dumping information so people can better get equipped on how to utilize this information and file claims with the court. So, peace.